I'm good. Mr. Puri.
Namaskar, sir. This is Professor Vijayendra Kumar from Nagpur. Welcome you to the program, sir.
Thank you. Welcome.
Professor Sonavare, has Professor Nuzha joined us? चेक करो ना मैडम और पीआईसी साहब। हाँ बिल्कुल स्टार्ट करवा दो, जैसे मैडम आएंगे तभी स्टार्ट।
हाँ मैम ने ज्वाइन कर लिया है।
अच्छा मैडम ने ज्वाइन कर लिया है, चलो लेट अस स्टार्ट विद द प्रोग्राम। Sorry everyone, we are a little bit late just because of some technical issues. Our guest, she could not join us. Now we start with our program. Yes, our anchor Shreya.
Yes, ma'am, I'll start.
Yeah, Shreya Samriti, please start.
Pray that for the glory of God and in the pursuit of His justice, I may be trustworthy with confidence, keen in study, accurate in analysis, correct in conclusion, able in argument, loyal to clients, honest with all, courteous to adversaries, and ever attentive to my consigns. Sit with me at my desk and listen to me with my client's tales. Read with me in my library and stand always beside me, so that today, in order to win a point, I do not lose my soul. A very good evening to respected dignitaries, esteemed judges, teachers, and all the participating teams. We welcome you all to the SK Puri International Moot Court Competition Justified 2020. The program is being organized by Law Center 2, Faculty of Law, University of Delhi, in the remembrance of senior advocate, late Shri S.K. Puri. To have an auspicious beginning to our program, I would like to invite Ms. Ankita, a student of Law Center 2, for the Saraswati Vandana.
Jayati Jaya Jaya Ma Saraswati Jayati Veena Vadini Jayati Jaya Jaya Ma Saraswati Jayati Veena Vadini Jayati Shvetambari Mata Jayati Jaya Swaradayani Jayati Jaya Jaya Ma Saraswati Jayati Veena Vadini Jayati Jaya Jaya Ma Saraswati Jayati Veena Vadini Jayati Padma Sana Devi Jayati Jaya Swaradayani Jayati Jaya Jaya Ma Saraswati Jayati Veena Vadini जयति जय जय मा सरस्वती जयति वीणावादिनी जयति वीणावादिनी जयति वीणावादिनी.
Thank you so much, Ankita, for giving such a gracious start to the event. Law Center 2 is a premier institution and is known for its qualitative teaching, research, and other co-curricular and extracurricular activities. It is one of the best institutions in the country which offers the 3-year LLB program. Talking about the man himself, the first generation lawyer, Mr. S.K. Puri commenced with a modest practice from a small wooden bench under a tree in Tees Hazari Court. With his sheer grit and determination, he rose to become a successful lawyer and was designated as a senior advocate in 2001 by the Delhi High Court. Apart from being a consummate lawyer, Mr. S.K. Puri was endowed with great leadership qualities. Besides being the Joint Secretary for the Delhi Bar Association, Mr. Puri was also elected as the Honorable Secretary for Delhi High Court Bar Association for as many as 6 consecutive terms between 1974 to 1985. Mr. S.K. Puri was also an avid reader and a quick learner. Having been bestowed with a photographic memory, he was also referred to as the ready reckoner among his peers. Mr. Puri has always reiterated and stressed on the 3 P's of practice, and that is preparation, presence, and perseverance. And his charisma as a lawyer was unparalleled and unmatched.
We have with us today his illustrious son, Mr. Sachin Puri. Sir is having the honor of being one of the youngest lawyers to have been elevated to the stature of a senior advocate. He instituted this moot court competition to commemorate his father and to provide a platform to budding legal minds to enhance their skill and master the art of advocacy. We are extremely honored to have you, sir, as dignitary for the event. We welcome you to your alma mater. We have with us Professor Mahavir Singh Talan, the professor in charge of Law Center 2, Faculty of Law, University of Delhi. Sir is a pioneer in the field of constitutional law, administrative law, the Indian legal system, criminology, and jurisprudence, and has an experience of more than 20 years in the field of legal education. I would request Professor Mahavir Singh to kindly give the welcome address.
Hello, am I audible? Yes, Ankita.
Yes, sir.
Yes, sir. Yes, sir.
Yes, sir.
Thank you for inviting me on the stage for delivering the welcome address for the annual International Moot Court Competition Justified 2020. Before I delve into the core of the address, I would like to make it clear to the audience that even during the pandemic, which has put the world at halt, we, the entire workforce of Law Center 2, has been proving each and every day that there can be a way and means of keeping legal education in a continuous flow, ready to be imparted and absorbed. This virtual international moot court competition is one of the ways by which the Law Center 2 has again proved that even the sky is not the limit for us, and we go beyond that ecotone. It is with deep respect, joy, and honor that I would welcome the chief guest of the session, Honorable Justice Ataur Rehman Masoodi ji of the High Court of Judicature at Allahabad. Whatever I will say about his lordship now will only be the touching his description superficially, He has around 25 years experience as a lawyer in various high courts and Supreme Court of India, where he excelled in many areas, including constitutional law, environmental protection, administrative law, and service matters. His experience and expertise catapulted him to join the High Court as a judge in the year of 2014. A look at the judgments can give a complete picture that he is a justice in the real sense, and it can be substantiated by the words of the judge himself, where he says, while the courts of law must maintain a distance from making an estimate of political gain or loss, it is the duty of the government and the opposition to deliver more solutions to public grievances instead of engaging in conflicts. In his another judgment, he said the applicants who have prayed for bail, even though they are foreign nationals, cannot be deprived of their personal liberty except in procedure established by law, and that were also entitled to equal protection of law and equality before law. Honorable Sir, I again welcome you, sir, and I feel profound privilege to have you here. With deep respect, honor, and joy, I welcome the guest of honor, Professor Vijandra Kumar, Vice Chancellor, Maharashtra National Law University, Nagpur. Professor Vijayendra, in addition to being an astute academician and research scholar, wherein he has authored numerous books and articles, he is a recipient of the well-known Meritorious Law Teachers Award for the year 2019, and also has an experience at the bar prior to teaching. He is the founding Vice Chancellor for the Maharashtra NLU Nagpur, and has been the Vice Chancellor, National Law University and Judicial Academy of Assam, and also the Registrar of Nalsar, Hyderabad. And not to maintain, he was appointed as a visiting professor at King's College, London. He is an advocate of ICT-based techniques in teaching and learning, and what better guest could initiate this virtual competition? Professor Vijandra Kumarji, it is a pleasure for us to have you here. Last but not the least, I welcome the guest of honor, another astute scholar and advocate of environment protection to make it pollution free, and advocate of the rights of women and child and their access to means of development for achieving equality and justice. I welcome Professor Nujit Parveen Khan, former Dean, Jamia Millia Islamia. In her honor, I would like to make a declaratory statement that it was under leadership that Faculty of Law, Jamia Millia Ismailia, made a great strides and became one of the leader of legal and higher education in India. I take this opportunity to even congratulate her on the top ranking of the university among the central universities under the ranking released by Ministry of Education, Government of India. Professor Vijay, it is my immense pleasure to welcome you, ma'am. I also welcome Mr. Sachin Puri ji, who is not only a senior advocate in Delhi High Court, but also has a big heart to commit himself to his alma mater by taking his time out of his very busy schedule to help students of Law Center 2 to hone their mooting skills in a competitive environment. I am proud to say that the first S.K. Puri Memorial Moot Court competition was held in 2017 when I was the convener and Dr. Anupam Jhaji was the co-convener of Moot Court Committee of Law Center 2. Mr. Puri and Law Center 2 are committed on the path of excellence in the core activities of legal education. This time, the subject of Moot Court competition is arbitration, which has emerged as a prominent field of legal practice all over the world. Organizing an international Moot Court competition on arbitration shows how both of us are committed to the journey of excellence. I again welcome, all my senior colleagues, my Professor Raman Mittalji, Professor Sarabjit Kaurji, our Dean Professor Vandanaji, our Professor V.K. Ahujaji, Professor Kiran Guptaji, and other senior faculty members, Dr. Anupam Jhaji, Madam Pinky Sharmaji, Dr. Rajni Abhiji, Dr. Shabnam, Dr. Bhageshwari, and other my esteemed and distinguished colleagues of Law Center 2. I welcome all of you and thank you very much, all of you, for joining us. Thank you, thank you, thank you.
Thank you so much, sir. It brings to us utmost joy in welcoming Professor Dr. Nuzhat Pareen Khan, former Dean of Jamia Millia Islam. Professor Khan shares a vision of promotion of quality-centric teaching and research and making legal education system in tune with sustainable social economic development of the nation. Her PhD on the topic, Legal Control of Air Pollution, Problems and Perspectives, was awarded publication grant by the Indian Council for Social Sciences Research, Ministry of Human Resource Development. It was published as a book accordingly. Ma'am was invited as a keynote speaker at the 7th Academic International Conference on Interdisciplinary Legal Studies at Harvard University in 2007. Professor Khan has published more than 50 research papers in prestigious referee and peer-reviewed journals covering diverse areas of law. Ma'am, we request you to guide the eager students.
Audio muted.
Professor Dr. Nuzhat Pareen Khan.
Can you hear me,
Ma'am.
please? Can you hear me? Samriddhi?
Yes, ma'am,
Am
you're
I
audible, ma'am. Yes, ma'am.
audible? Okay, thank you very much. Thank you. Thank you very much. On Professor Mahavir Singh, Professor in charge, Law Center, Faculty of Delhi. Ataur Rahman, Masood Aiko, Professor Vijayendra, Vice Chancellor, NLU Maharashtra, Professor Pinky Sharma, who is the convener of S.K. Puri International Moot Court Justified 2020, all the faculty members, and of course, my dear students. First of all, I would like to congratulate Professor Mahavir Singh, good friend of mine, and Professor Pinky Sharma, a very good friend of mine, and the convener and head of the Moot organizing committee, all the committee members, Dr. Monica Chaudhary, Dr. Naresh Mahipal, Dr. Pramod Tiwari, Ms. Sumiti Ahuja, student conveners, Mr. Kumar Abhishek and Ruchika Bhatt. Very many congratulations to organize Moot Court on such a relevant topic in today's time. I really congratulate you people. My thanks for inviting me to be a part of this event. Highly thankful to be a part of this Delhi University Moot Court Justified. Now, since the topic of the moot court is, I have gone through your problem also, and also I've been told that it is on international arbitration law. And this is now getting very popular. International arbitration is basically a method of dispute resolution whereby the parties agree to have disputes resolved by one or more private persons. They can be, of course, called as arbiters. They are chosen parties. The people are getting ready to get their dispute resolved by these individuals as arbitrators, rather than setting their disputes in the court of law. And this is happening to be, this is preferred nowadays, and these methods are called as alternative means of settling disputes.
Professor, we can't hear you.
Madam, you are not audible.
I think there's some network connectivity issue with
Yeah.
ma'am. We will surely listen to her. In the meanwhile, I would like to introduce you to our second guest of honor, Professor Dr. Vijayendra Kumar, the Vice Chancellor of Maharashtra National Law University, as a second guest of honor for today's event. Sir was a Commonwealth Fellow UK in the year of 2009 and was awarded for the Meritorious Teacher Award in 2019 by the government of Telangana. Before joining the Maharashtra National Law University as its founder Vice Chancellor, Sir has held the post of Vice Chancellor of National Law University and the Judicial Academy in Assam. An astute academician and a research scholar, he has numerous research articles and books to his credit. He has published more than 70 research articles in reputed law journals on Hindu law, research methodology, and legal education, and has contributed several book reviews and papers in several books. He is now on a mission to establish a new national law university in city of Nagpur with a student-centric outlook, which should be a world-class university in the due course of time. It is a moment of proud and privilege for Law Center 2 to have you with us as a guest of honor. I would request Professor Dr. Vijayendra Kumar to kindly say a few words to the audience.
Yeah, good evening to all. Honorable Sri Justice Ataur Rahman Masoodi ji, Judge Allahabad High Court, is the example of the best advocacy which we can see today. We have a Professor Nusrat Parveen Khan, the former Dean, Faculty of Law, Jamia Millia Islamia. Professor Mahavir Singh, Center in Charge, Law Center 2, Faculty of Law, Delhi University. Professor Pinky Sharma, convener of SK Puri Moot Court Competition. Advocate Sachin Puri ji, faculty members of the Law Center 2 in general and Delhi University, Faculty of Law. Moot Court team of the students, the volunteers working with the Moot Court team, participants, especially in this pandemic situation, still making efforts virtually to connect with the competition. That indicates their commitment to the legal profession. IT department people from the Law Center and Delhi University, the volunteers, ladies and gentlemen. Am I audible?
Yeah.
It's a matter of really, of course, a privilege and proud. Talking about a competition in front of a sitting honorable judge from the largest high court of the country, that is Allahabad High Court, which gives a positive vibrance to these budding lawyers. And I'm sure they are well prepared virtually to speak on their or submit their arguments, oral arguments. Written arguments do not make much difference in a present pandemic scenario, because they are always submitted well in advance to the organizing Moot Court committee. But the oral arguments, of course, is a new normal for these budding lawyers. And it's a challenge to the law teachers, the law practitioners, and of course, honorable members of the bench, irrespective of which court they are. So organizing Moot Court competition is not that easy in this pandemic situation, but I really appreciate the efforts taken by the team of Professor Mahavir Singh, is my old friend, contemporary. We come from the same alma mater. And of course, Professor Pinky Sharma and her team along with the students. And more than that, the daring of these participating teams, the Moot teams, in spite of having limited resources towards the remote access of their digital library from their respective institutions, wherever they are registered and they are on the road, being a student of undergraduate degree course, if I'm not wrong. But in spite of having all these odds, they dare to prepare and present their oral arguments before a panel of well-trained professionals who are going to adjudge these multiple rounds of this Moot Court competition in the honor of beloved senior advocate S.K. Puri. And I really thank to the members of S.K. Puri, those who are keen to carry on the lineage of Mr. Puri, and they contribute in whatever way they wish to contribute in the growth of the budding lawyers of the country. Moot Court exercise basically is nothing but the part and parcel of clinical legal education, which the Bar Council of India promotes through clinical papers, and it is one among those 4 mandatory clinical papers. And the law schools today, be it private or public, they promote the students, they support the students in their efforts to perform or let them check their credentials, whether they can be a good orator before a formal court of law, while they are still in the degree programs wherever they are registered. So it is really a good gesture on the part of the organizing committees and institutions where they uphold the honor of these participating mooters towards their drafting skills, finding of law skills, understanding and appreciating factual metrics, which has been put into the format of a Moot Court problem as it is known. As my just previous speakers mentioned about the problem, it is on international arbitration. Okay, and we call it a ADR. ADR is also a part of as a mandatory paper of clinical legal education as given by the Bar Council of India. And we have seen in very recent times, the Honorable Chief Justice of India promoting mediation and conciliation, which is nothing but offshoots of this ADR mechanism. But what I understand, the time has come, we should not call ADR as alternative dispute resolution mechanism. Alternative should be replaced with the appropriate dispute mechanism system. What we all are hoping as a educationists in the country, rather throughout the world, the new normal is going to be a flood of cases on the courts, irrespective of the nature the court is and courts are. In such a situation, alternative, rather appropriate dispute resolution mechanism is the need of the hour, and these budding lawyers are the right professional, those who are socially relevant, technically sound, and professionally competent, and they are going to be the new normal of the legal education as well as legal profession. Because the Supreme Court of India team on e-courts or e-committee under the chairmanship of Honorable Sri Justice Chancellor Sir is working tirelessly on e-lawyering, e-courts, and e-filing. And today's program is the best example to prove that the students of law, irrespective of whether they are the student of 3 years program or they are 5 years integrated programs, they are very well prepared and they are ready to take the new normal even in virtual format. And this competition in next 2 days will prove, though there will be only one team which will win the competition and there will be another team which will be runners up, but all of them, those who are daring to participate, we should understand and welcome them, rather honor them. All of them are the best, daring, new normal advocates. Of course, technology plays a major role in today's advocacy. And advocates are nothing but, they are also the officers of the court. The presiding officer and officers cannot reach to the conclusion unless these so-called or technocrat, the advocates perform to the best to their abilities, keeping in view the facets of law and the technology and putting them into the proper factual metrics. But at the same time, I warn my students, the budding lawyers, access to justice is still in the country is far away from the reality. It is not everybody's cup of tea. The poor litigant, the underprivileged litigant, the so-called needy litigant is still in search of the best lawyer. And the budding new normal lawyers are supposed to understand the pain of the litigant, behave professionally, perform professionally, remain objective on the merit of the matter, and try to convince the presiding officer of the court. Then only we can think about the justice to all is going to be materialized soon. Unless these budding lawyers take things professionally, objectively, come out from their comfort zone, understand the pain of the litigant, access to justice and justice to all will remain again in the books. Let us bring them out. Let us give our share of contribution in upholding the rule of law, the law of the land in the best possible ways. My best wishes to all the participating Moot Court competition teams, and of course my best wishes are also due to the organizing students Moot Court committee, their volunteers and their mentors. Thanks a lot. Thanks for giving me the chance to address you and share my views with all of you. Thank you very much. Thanks a lot.
Thank you so much, sir, for your words of wisdom. Due to network connectivity issue, I think Nusrat ma'am has left us. So we would really like to invite her to complete the speech.
Are you inviting me by chance?
Sir, if you want to say something more, you can, but you are inviting
Yeah, I have
Nusrat
concluded
ma'am.
my speech and I'll be
Yes,
happy to make this announcement to my participating team to understand these technical glitches which even the honorable judges are also experiencing these days. And what had happened yesterday in the court of Justice Laliji, that is a kind of best example for all of us to understand and behave professionally. Over to you, please.
Thank you so much, sir, for understanding. I think ma'am will surely give her the stage when she'll join, as soon as she joins. We are delighted to have with us Honorable Mr. Justice of Allahabad High Court, Atur Rahman Masoodi, as the chief guest for today's ceremony. Born in Kupwara district of Jammu and Kashmir, Sir completed his graduation in science from Lucknow and chose to study law from University of Lucknow. Prior to taking oath as a permanent judge of High Court in 2016, he practiced mainly on civil, constitutional, service and environment matters in High Court of Allahabad, Lucknow Bench, Central Administrative Tribunal, Delhi High Court and High Court of Uttarakhand. It is a moment of proud and privilege to have you with us today, sir. I would request you to kindly enlighten us with your words of wisdom. Over to you, sir.
Good evening, everyone.
Good evening,
A
sir.
very warm welcome to the participants in this international event of Moot Court. We have with us Professor Mahavir Singh, Professor in charge, LC2, Faculty of Law, Delhi University. We have two guests of honor, Professor Vijayendra Kumar, Vice Chancellor, Maharashtra National Law University, and Professor Nuzhat Parveen Khan, former Dean, Faculty of Law. And Dr. Pinky Sharma, Convener, Moot Court Committee, Law Center 2, Faculty of Law, Delhi University. Without making a reference to late S.K. Puri, a senior advocate whose contribution and achievements for commemorating his presence and relevance even today brings us together. And the participation is more attractive when we see his worthy son, Sachin Puri, again a senior lawyer of Delhi High Court, with us today. When I was going through this mail sent to me by Dr. Pinky Sharma, I just glanced through the life history of late S.K. Puri. I noticed two significant things from his life history. Firstly, his leadership abilities and his achievements as a lawyer and his skillfulness, all that was there. But he played a key role while being a representative of members of the bar at Delhi High Court to raise demand for chambers for the lawyers. And the first block of chambers was built in the Delhi High Court premises under his leadership. This demand certainly has a relevance and must be remembered because it has something to do with the accomplishment of our legal system. We must remember that no legal institution can be made functional without accomplishment of its various dimensions: infrastructural and human resource. These two combine, develop an institution which ultimately serves the human cause. Congratulations to the worthy son of late S.K. Puri, who is extending his constant moral support to the students of Delhi University by not having established this trust for the namesake, but as far as I understand, this prize which is at the back of this program, which is motivating, which has a motivational power for the students to come forward and participate in such a program, is backed by a handsome financial background. There are prizes, and the highest prize is 50,000 rupees, and so on and so forth. The total amount corresponds to nearly 3 lakhs of rupees. If it is financed by Mr. Puri, the senior advocate, the role is commendable. For a worthy son to remember the contribution of his father, who has left behind a great force of guidance for the students, for the lawyers, for the institution as such. My participation in this program is also relevant for the reason that when I see my growth in the light of what late S.K. Puri has contributed to the institution, I also find that late S.K. Puri was a first generation lawyer, and it was perhaps this motivation, if not read, but imbibed through inspiration, that I left my home state and I came out of the state and began as a first generation lawyer here at Lucknow. So the lesson is, for a lawyer to grow, he has to first and foremost face this fear courageously, that even if he's a first generation lawyer, yet he should not worry and should dare to come forward and face the realities of life courageously, with the belief that his hard work and his efforts one day will materialize not only into a material gain, but will fetch him due recognition which he aspires. When I started in such an atmosphere without any background, the commitment was that if I sail, I sail. And even I was prepared to drown, but I never and ever thought that after having studied law, I must not join legal practice. And I attributed a lot of hope to this profession, which with the passage of time, through happiness and bitterness that one experiences in due course of time, ultimately fructifies into something that brings you social recognition and dignity. Once you face the situation courageously, you live a dignified life, and I have no doubt about it. Now, coming to the moot court and the moot problem of today, which is that of international arbitration. This legal product has its own unique utility. And I see that the consumers of this product, when we talk of international arbitration, are those who deal in trade and commerce, who deal in investment, and broadly, the commercial area of conflict arising out of the agreements which the parties enter into when they arise. Necessity for an institution like arbitration forum for international conflicts arises, and history tells us that this is one area where the plight of individuals was perceived internationally before the individuals could set up some mechanism of their own. We have governing principles for the sovereign states, liberalism, socialism, so on and so forth. But once the growth of human relationship and trade and commerce grows, these geographical boundaries are crossed. Relationship multiplies, it globalizes. That is why perhaps the time when the League of Nations was in its making, people thought that there should be some mechanism for the individuals whose capabilities in business and trade is beyond the territorial limits of a sovereign country, If they enter into business relationship across the borders, how would the resulting or the arising disputes out of their business relationship be redressed? Our domestic courts had its own limitations. That is why, though it being for the purposes of international arbitration an exclusive mechanism, yet we call it alternative. Alternative it is for the reason because we do not have any other mechanism. The other mechanism is the course of justice which the welfare states have established within their territorial limits. But they have their own difficulties. The difficulties which were perceived were manifold. Looking from the point of view of our country, we see that the pace at which the litigation proceeds is very time-taking. This was not acceptable to the people who were entangled in some conflicts arising out of their business relationship. So, this was not viable. This difficulty was perhaps the driving force towards conceiving an idea of arbitration, where the parties had an option to choose a judge of their own, to choose an arbitrator of their own. Once that option was exercised, it was also open to the parties to evolve a procedure as simple as it could be. Even the arbitrators, the choice of arbitrators, it was so wide that like it could be exercised from amongst the persons beyond the territorial limits of a country, sovereign country, wherein the business establishment was operated or where the conflicts arose. Now, what is interesting about international arbitration is that it is consensual. Yet, because the human beings have a peculiar problem of trust and faith, when the disputes multiplied, then doubts started arising. Like, suppose there were two companies, one from one country and the other from other country, and they had to resolve that. Well, in the event of any dispute arising out of an agreement, they will subscribe to arbitration. Then the question was, where should the
Noted.
I'm sorry, my lord, you have muted yourself.
am I not audible?
Yes, my lord. Now you're audible.
Now it's fine. Yes.
So all that what I spoke was, it went in vain?
No,
Yes.
just 2 minutes.
Just about a minute, my lord.
So I had I muted it?
Somehow it got muted, my lord.
So nothing could be heard by anyone.
No, for the last 1 minute only, not beyond that.
So 1 minute.
Only
Last-
30 seconds.
That's it.
I'm sorry I could not mention the name of Professor Ved Kumari ji,
No.
who is only professor from Delhi University whom I have met personally. And that too after mustering great courage. So what I was talking about, I was talking about the evolution of this arbitration as a process of redressal mechanism of disputes between the two parties belonging to two different countries. But then where to seat the arbitrator? Natural phenomena is, as the human weakness goes, that both the parties, suppose the seat is stationed in one country and the other party belonging to the other country will have a sense of fear that, well, the arbitrator could be influenced, or for some other reason, some insecurity, state of insecurity may creep in. So this international arbitration procedure provides us an opportunity, to these parties to fix the seat of arbitration even at a place which somehow or the other is not connected to either of them. Now the award can be rendered elsewhere at a third place to which both the parties are not related somehow or the other. The question is that having a seat of arbitration to the satisfaction of parties is also one of the dimensions of this agreement, which envisages a clause of arbitration. It's a very important clause. Now this agreement which the two parties resolve is a document again which the design of which has to be conceived by whom? The people doing business may not have adequate knowledge of laws. Now the role of a lawyer begins here. The scope where your education will lead you to a bright future is to know the skills of drafting the agreements between the two partners, between the parties to a business cooperation or business activity. This is one area relevant for the students to focus on, that they must have good skills of drafting agreements which facilitate arbitration, and where they have also to take ample care that the agreement has to be designed in a way so that the faith and trust of parties, it is not shaken. Once that trust and faith is built through this process of drawing up agreements of good quality, then it will give an impetus to the growth of this institution of arbitration. So this is one relevant area to which the students must focus on. The other area is procedure. The procedure, why have our domestic courts, why has our domestic adversarial litigation failed? It has failed because we took shelter of the procedural laws so much so that we have derailed completely the smooth functioning of our civil administration of justice. Today, our litigant does not know as to what the life of his case, civil case, or a simple grievance is going to be. This has shaken the faith and trust of our domestic litigation to a great extent, whether we accept it or not. Flow of cases to the courts is not a certificate of our trust and faith. It is the delivery of result that will fetch and will maintain and will keep intact that trust and faith. And this mistaken belief which we are building or which we have accepted for ourselves is perhaps a very dangerous thing. And it is posing a very serious challenge to our regular course of administration of justice. In drawing up the agreements, the procedure which is to be followed between the parties has also to be focused on by the draftsmen of the agreements, so that the expediency, which is the basic purpose of creating this alternative mechanism, does not suffer. There is a third dimension also in the arbitration proceedings, and that is about the quality of judges. We have an arbitration clause. We have firstly the business, which is bound to lead to disputes. Then we have an area to deal with that, well, there is a mechanism, there is an agreement which provides for arbitration, and it is very skillfully drafted. Then there comes a third party. The third party is the nominee. That is the judge. The product of arbitration, adjudication through arbitration, must be competent. If world is open for nomination of an arbitrator between the parties, then this competition has to be an effective competition between not only the traders, but the countries also. Because every infrastructure or an institution for international arbitration has to be accomplished within a state. Whether we would depend upon the assistance of the state to come forward today, like in our country, our arbitration centers are a part of either the district courts or they are a part of the High Court. Unless there is a grant by the government, there is no space. Now, is this idea of arbitration for the purposes of its institutionalization to be taken care of by the traders themselves whose disputes you are resolving, or you have to resolve institutionally, or there should be some interference of the government for providing this infrastructure, which may also include, once there is interference of government to provide infrastructure, then the third dimension comes that the government may also have a say for appointing or for nominating the arbitrators, through whom certain things can be influenced one way or the other. If this institution is to be made wholly independent, then is it the businessman who has to accomplish the institution, or is it the government which will come forward and facilitate its citizens within an institution of this kind? This debate is very long. It is not simple. Today, what should be the matter of concern for the students is in the independence of an institution which is to administer justice. Faith and trust has not to be compromised. The accomplishment of an institution is not to depend on the aids and supports which are extended by the government, by the governments, or through other sources which can be doubted. So this is another area. That is why in some countries, there's one more aspect. Like if you see that the traders, they are in conflict, and as per their agreement, they have to resort to the arbitration proceedings. Yet these arbitration proceedings will not materialize overnight. But there is a third person watching in the market, that two people are in conflict, and this resolution has to take place within a span of time. But the parties cannot wait. He has his own business of evaluating the end result of this litigation. He will come forward. He will buy this litigation. He will make an evaluation on the basis of the advice of legal expertise that the end result of this dispute is going to be this much of benefit. The third party will make good that much of loss or gain to the party litigating, and he will buy this benefit. Now, is it for that party to accomplish this institution or facilitate certain institutions for the purpose of development? What the worldwide scenario as on date is, like we have International Chamber of Commerce. This is one institution working at the international level for the redressal of international arbitration. We have LCIA, London Court of International Arbitration. Please see the nomenclature of these international arbitration institutions. They have attracted a great deal of clients worldwide. Like there is ICDR. This is American Arbitration Association. Like there is Singapore International Arbitration Center. Like there is Hong Kong International Arbitration Center. And there are many more likewise which have developed as an institution for the purposes of international arbitration. So a competition between these institutions worldwide is seen. The question is whether we have any scope in India for being a competitor to these institutions. Otherwise, which business party or which business entity would like this country to be made as a seat of arbitration, where you people, because of having an advantage of the language that you speak, can avail of this, can avail of the facility, or can avail of the benefit of this arbitration process. In 2019, of course, we have brought about a law, but this law has not delivered us the results which were targeted. There is still some confusion with respect to the laws applicable, and these disputes have to be deliberated, they have to be considered, and an effective mechanism at par with the international scheme of arbitration centers has to be developed so that some work. The difficulty is that in globalization, it is not only the institution that matters, but the language also matters. The business laws also matter. Thanks to some international conventions like Geneva Convention and the New York, where at least these business people, they have some respite. Otherwise, suppose the international arbitration is to be facilitated here in India, you will see, if you study deeply, we have not come up with a kind of infrastructure which is required of, or which will take our country a leap forward for competing with those institutions which have already established and which have already taken away a great chunk of work from this country to elsewhere. Budding lawyers have to have a broader vision of this sector of litigation, and if the key areas are not addressed, key areas regarding the establishment of the system, the basic rule, like an advocate when he starts with the legal profession, I have this experience that everybody wants to have a chamber. Then with the passage of time, he has a client. Now when he has a client, then he has some objectives about the case at hand. The objectives about the case at hand can be twofold. Either the advocate, either the person assisting will try to multiply his financial gain, or he may have an idea. He may, in order to win over the client, he can also evolve certain mechanisms like compromise before asking him to resort to arbitration. If there is any, these are chamber works, because these are the basic inputs through which you can establish a scheme of thought. Suppose you explore a possibility of compromise and you deliberate on that. The party, the ailing party, will at least have a faith in the expert whom he has contacted, that well, at the threshold of the proceedings he suggested me something, and better I deliberate with my rival on this issue. If he compromises on this, then nothing further has to be done. So the tendency of a lawyer towards litigation has to be towards the resolution. Having this 6-7 years of practice, if anything satisfies me, what is the best judgment? Suppose I question myself, what is the best judgment? The best judgment, many people can say many things. Somebody may say that a judgment which is well written, which is well reasoned, which deals with the law in a very lucid and with a deep thought. But many times such things do bother. That is one object of the judgments. What has satisfied me is that if the two litigating parties before the court are satisfied and the judgment that you render is acceptable to both of them, this brings them back on the track of life, and this saves their lot of time. So the best judgment according to me is that which does not leave any scope for appeal, which does not leave any heartburning between the two parties that they take up. Like I had an opportunity of conducting a Lucknow metro case. When the judgment was rendered, everybody expected that, well, this problem is going to multiply because the matter will go to the higher court and there, here and there. But what was satisfying was this, that the parties there, that was a situation where the blacklisting of a company which was to be disclosed at some point of time, some principle was laid down, but then they accepted it, and that almost became an acceptable norm to all these companies, and in future that became a part of their basic structure of the tender design. But when it did not go to the Supreme Court, at least there was a level of satisfaction. In one more case, I may tell you that once the agreements are drawn in a faulty way, like we have petroleum business in India. And these petroleum companies, when they establish retail outlet dealerships, there is an arbitration clause in those agreements of allotment of retail dealership. Every dealer in that agreement deals with two things: the property upon which that business is run, that has its own relations with the company. The other is quality and quantity checks. For quality and quantity checks of the product, there are marketing discipline guidelines. Now, in one of the cases, what happened was that the arbitration clause was there, but in one of the clauses in the agreement, there was a mention that with respect to quality and quantity checks, the marketing guidelines will prevail. Now, marketing guidelines provided for a different course of appeal and other forum. The agreement provided that any dispute arising out of the agreement would be subscribing to the arbitration proceedings. Then, arguing on the strength of that clause, I had argued that, well, it excludes arbitration to this extent of marketing guidelines which were made applicable, and to the extent of law which was applicable with respect to the quality and quantity part. But later on, when the courts intervened on that strength, the very agreement was redesigned by the companies, and in future they rectified their defects. So these agreements by itself are a great deal of work for the lawyers, for the people who are interested in this practice, and what basically must be focused on, that the institution has to be established which delivers optimum results to the beneficiaries, to the consumers of justice, and expediency, less procedure, and one more aspect of coming forward to ensure expediency, if some sense of minimizing the issues of conflict, if lawyers work in that direction, perhaps this area of litigation will substitute a great deal of work, and you people will have ample opportunity of settling in this area in a very dignified and a very fruitful way. And you will never regret to opt for law studies ever in life. And our own universities and our own institutions, educational institutions, will also work on that plane. One more aspect which I will pass a passing remark is the superintendence of the, firstly, now you establish a system, now you have a judge, you have a lawyer, you have agreements, you have ample work. Then the judgment which comes and the laws which should be applicable, the judicial superintendence has also derailed the speed of this redressal. From the point of reference, intervening period, and the ultimate arbitration award. This is all subject to judicial superintendence. more we minimize the scope of interference through this jurisdiction of judicial superintendence, more fruitful would it be, and more fruitful it would be for the business also. So that is yet another area which may not be relevant so far as your today's problem is concerned. Today you have a different problem between the two different parties. Now the seat of arbitration is fixed, the laws applicable have been fixed, and all that is there. And I'm sure that you will travel into the relevant areas of arbitration and help these two parties settle this dispute honorably and to their utmost satisfaction. It is just on the lighter note. I hope if the parties appearing for the litigants arise at a compromise, it would be more fruitful. So that is how I look at this moot court, and I have perhaps taken more time than what was necessary. And my way of talking to the students is I always feel guided by a saying of George Bernard Shaw when he says that we are made wise not by the recollection of our past, but by the responsibility for our future. So that responsibility for our future was actually the concern with which I wanted to talk to the students. And I think there will be some better occasion or some other occasion also when I may have an opportunity of talking to you on some specific areas. But leaving that scope open, I should conclude with this much of discussion today. And I wish that all of you have a bright future in the to the Law Center 2 of Delhi University to have invited me for this interaction today. I do not know how far it has been fruitful to the students, but it was a privilege. Thank you. Thank you very much.
Thank you so much, sir. This brings us to the end of today's event. Now I request Samitra, student of Law Center 2, Faculty of Law, to conclude with national anthem.
It's not audible.
It's not audible.
Ruchika Di, it is not audible. Thank you so much, Samitra. Now I request Dr. P. vote of thanks.
Thank you so much. And now when we have come to the end of our lively gathering, and prior to the winding up of this event, I would like to express a few words of my gratitude to all my guests and the person present on in this occasion. And myself, Dr. Pinky Sharma, I extend my warm and graceful good evening to our most honorable guest of the day, our faculty members, our worthy teachers, our participants, our organizing committee, and everyone who are gathered here. Now, it is my privilege to propose the vote of thanks and acknowledge the contribution of those who really have worked hard to make this virtual moot court competition happen. I, on behalf of Law Center 2 and I have fraternity of my institution, and from my first of all, I would like to extend my most sincere thanks to the Almighty God for making today event a resound success. With His blessings and grace, we are not able to make this event happen. For the Law Center 2, this is the first virtual competition, and without his blessings it could not be made possible because during this pandemic situation. And I extend my really hearty vote of thanks to our chief guest, Justice Masoodi, who has spared his valuable time from his busiest schedule to grace the occasion. Sir, today we had an opportunity to hear your thoughts, and this sincerely is going to be encourage us in the future events, and especially for enlightening about our own moot court competition, that is the International S.K. Puri Memorial Moot Court Competition. You have told us many things about Advocate S.K. Puri also and his great son, Mr. Sachin Puri. Sir, you have my special thanks to you for the excellent coverage of the topic of our moot court competition, and that is the international arbitration law. You have enlightened our minds and have shown us a new path, and I think personally feel that you have motivated many of us, my students, my colleagues, and to me also, that we should study international arbitration law with details, because you have encouraged us to study this subject, which is you have created interest for this particular subject, and you have imparted knowledge about this subject, and I'm sure that our participants, they will definitely be benefited. Not only the participants but our present students of the second and the final year, they will also get they are also getting benefited, and especially because you have give a delivered a thought-provoking speech, and especially for the advocacy skills and the lawyering skill, and they will become definitely the future advocates, and they will be very successful in their life. Before I proceed further to thank my other guests and other faculty members, I would like to inform you that today we have an excellent sportsman with us. Any guesses? He is the master blaster. Today's days we are having IPL fever. Any guesses? That in our from our participant, you can tell me that we have an excellent person who is considered to be the master blaster for cricket. Any guesses? He is none else than our chief guest, Justice Masoodi. Today only I came to know, sir. Thank you so much. You are an excellent sportsman, and I came to know today only. And I would like to inform you that sir always plays on behalf of the Indian team against the Delhi judges for NC Sikri Memorial Tournament, which is in the name of Father of Justice A.K. Sikri. Thank you so much, sir. Thank you.
Thank you. Thank you, sir.
That's why we are learning so many things beside this international arbitration from your sportsmanship. We have learned from you, sir. Thank you so much.
Thank you, sir.
Now, I would like my sincere gratitude is to Professor our Vice Chancellor, Professor Vijayendra, and to grace this occasion and share his opinion. Sir, deep sense of the appreciation about you that you have created, invite the students that they should participate in this the moot court competitions. Thank you so much, sir, for being with us. And I would like to, my special and big wala thank to my friend, Professor Dr. Nuzhat. And I'm sorry that we could not listen you because of this technical problem which madam is facing. Madam, she is a great, I have learned so many things from madam also. She is a distinguished writer. She is writing on, so she has written few books for women and the children. She was the former dean of the Jamia, and presently she is the chairperson of Internal Complaint Committee of the Jamia Millia Islamia University. Thank you so much, madam, for being with us. And sorry we could not, we are unfortunate that we could not listen you today. Thank you so much for with us. An event like this cannot happen. The wheel of this organizing international moot court competition actually rolled back last December, and which require such type of the events, they require planning and a bird's eye for details. And Mr. Sachin Puri, he contributed along with her team. Their team was very proactive and dedicated. I'm thankful to Mr. Praveen Sharma, who is actually dealing with us to make this event more successful. And I'm short of the words. Without their involvement, their willingness to take or complete this task beyond our comforts, it was not possible. Thank you so much, Mr. Sachin Puri, for being starting this international moot court competition in the name of your father. I will fail in my words if I don't mention that how this moot court competition could be made possible. This competition started with our former in charge, Professor V.K. Ahuja. This was his baby at that time, but now we have Professor Mahavir Singh. Both of them, they were have been the catalyst to stimulate us to do our best, and they stood pillars of the strength to make this event successful in all respects. Thank you so much, Professor V.K. Huja, Professor Mahavir Singh. My deep sense of appreciation is for my loving teachers for their utter efforts. And I would like to thank people who worked behind the scene to make this event happen. They ran from pillar to post to make all sort of the arrangements, and especially our technical team. I would like to thank our buddy rock stars who are the joint conveners for this event, and their day and night have done a wonderful job. All my teachers, my students, and they worked for whom? They worked for our participants who are coming for, who have participating. No doubt this is a virtual competition now. Otherwise it would have been, it is always considered to be the best of the event of the Law Center 2. Best event of the Law Center 2, which runs for 4 days, but the program or this preparation that goes for months. And that is not possible without the help and the guidance and the support and the cooperation of our professor in charge, our faculty members, and our teachers. I always say the backbone of every event is my students. Without their support, we cannot do anything. Thank you so much to all of you. And my special thanks to my senior faculty members who have graced this occasion, Professor Ved Kumari, Professor Vandana, Professor Kiran Gupta, Professor Sarabjit, and all other faculty members from my law center too. Thank Ruchika, I hope now this you are ready with a national anthem. Ruchika.
Yes, ma'am. Yes, ma'am.
Yeah, please.
भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जल शुभ नाम जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय
Thank you so much, Samitra. This brings us to the end of this glorious event. Thank you so much.
Thank you so much, everyone. Professor Ved, ma'am, how are you? Now this is our informal talk.